1. The Code on Wages, 2019. Arrangement of sections. Chapter I. Preliminary. Sections 1. Short title, Extent and Commencement. 2. Definitions. 3. Prohibition of discrimination on ground of gender. 4. Decision as to disputes with regard to same or similar nature of work. Chapter 2. Minimum wages. 5. Payment of minimum rate of wages. 6. Fixation of minimum wages. 7. Components of minimum wages. 8. Procedure for fixing and revising minimum wages. 9. Power of central government to fix floor wage. 10. Wages of employee who works for less than normal working day. 11. Wages for two or more classes of work. 12. Minimum time rate wages for piece work. 13. Fixing hours of work for normal working day. 14. Wages for overtime work. Chapter 3. Payment of wages. 15. Mode of payment of wages. 16. Fixation of wage period. 17. Time limit for payment of wages. 18. Deductions which may be made from wages. 19. Fines. 20. Deductions for absence from duty. 21. Deductions for damage or loss. 22. Deductions for services rendered. 23. Deductions for recovery of advances. 24. Deductions for recovery of loans. 25. Chapter not to apply to government establishments. Chapter IV. Payment of bonus. 26. Eligibility for bonus, etc. 27. Proportionate reduction in bonus in certain cases. 28. Computation of number of working days. 29. Disqualification for bonus. 30. Establishments to include departments, undertakings and branches. 31. Payment of bonus out of allocable surplus. 32. Computation of gross profits. 33. Computation of available surplus. 34. Sums deductible from gross profits. 2. Sections 35. Calculation of direct tax payable by employer. 36. Set on and set off of allocable surplus. 37. Adjustment of customary or interim bonus against bonus payable under this code. 38. Deduction of certain amounts from bonus payable. 39. Time limit for payment of bonus. 40. Application of this chapter to establishments in public sector in certain cases. 41. Non-applicability of this chapter. Chapter versus Advisory Board. 42. Central Advisory Board and State Advisory Boards. Chapter V. Payment of dues, claims and audit. 43. Responsibility for payment of various dues. 44. Payment of various undisbursed dues in case of death of employee. 45. Claims under code and procedure thereof. 46. Reference of disputes under this code. 47. Presumption about accuracy of balance sheet and profit and loss account of corporations and companies. 48. Audit of account of employers not being corporations or companies. 49. Appeal. 50. Records, returns and notices. Chapter 7. INSPECTORY cum Facilitator. 51. Appointment of inspector cum facilitators and their powers. Chapter 8. Offenses and penalties. 52. Cognizance of offenses. 53. Power of officers of appropriate government to impose penalty in certain cases. 54. Penalties for offenses. 55. Offenses by companies. 56. Composition of offenses. Chapter X. Miscellaneous. 57. Bar of suits. 58. Protection of action taken in good faith. 59. Burden of proof. 60. Contracting out. 61. Effect of laws, agreements, etc. inconsistent with this code. 62. Delegation of powers. 63. Exemption of employer from liability in certain cases. 64. Protection against attachments of assets of employer with government. 65. Power of central government to give directions. 66. Saving. 67. Power of appropriate government to make rules. 68. Power to remove difficulties. 69. Repeal and savings. 3. The Code on Wages, 2019. ACT No. 29 of 2019. 08 August, 2019. An act to amend and consolidate the laws relating to wages and bonus and matters connected therewith or incidental thereto. Be it enacted by Parliament in the 70th year of the Republic of India as follows. Chapter I. Preliminary. 1. Short title, Extent and Commencement. 1. This Act may be called the Code on Wages, 2019. 2. It extends to the whole of India. 3. It shall come into force on such date 1 as the central government may, by notification in the official gazette appoint. And different dates may be appointed for different provisions of this code, and any reference in any such provision to the commencement of this code shall be construed as a reference to the coming into force of that provision. 2. Definitions. In this code, unless the context otherwise requires, accounting year means the year commencing on the first day of April. B. Advisory board means the central advisory board, as the case may be, the state advisory board, constituted under Section 42. C. Agricultural income tax law means any law for the time being in force relating to the levy of tax on agricultural income. D. Appropriate government means I. In relation to an establishment carried on by or under the authority of the central government, or the establishment of railways, mines, oil field, major ports, air transport service, telecommunication, banking and insurance company, or a corporation or other authority established by a central act, or a central public sector undertaking or subsidiary companies set up by central public sector undertakings or autonomous bodies owned or controlled by the central government, including establishment of contractors for the purposes of such establishment, corporation or other authority, central public sector undertakings, subsidiary companies or autonomous bodies, as the case may be, the central government. E. In relation to any other establishment, the state government. A company means a company is defined in Clause 20 of Section 2 of the Companies Act, 2013, 18 of 2013. F. Contractor, in relation to an establishment, means a person who, I. undertakes to produce a given result for the establishment, other than a mere supply of goods or articles of manufacture to such establishment, through contract labor. Or E. supplies contract labor for any work of the establishment as mere human resource and includes a subcontractor. G. Contract labor means a worker who shall be deemed to be employed in or in connection with the work of an establishment when he is hired in or in connection with such work by or through 1. The 18th of December 2020, subsection 1, 2, 3, 10, and 11 of Section 42, to the extent relate to the Central Advisory Board. Clauses S and T of subsection 2 of Section 67, to the extent they relate to the Central Advisory Board. Section 69, to the extent it relates to Section 7 and 9, to the extent relate to the central government, and Section 8 of the Minimum Wages Act, 1948, 11 of 1948, vide Notification No. SO 4604, A, dated the 18th of December 2020, see Gazette of India, Extraordinary, Part 2, Sec. 3, E. 4. A contractor, with or without the knowledge of the principal employer, and includes interstate migrant worker but does not include a worker, other than part-time employee, who, I, is regularly employed by the contractor for any activity of his establishment and his employment is governed by mutually accepted standards of the conditions of employment, including engagement on permanent basis, and E, gets periodical increment in the pay, social security coverage and other welfare benefits in accordance with the law for the time being in force in such employment. H. Cooperative society means a society registered or deemed to be registered under the Cooperative Societies Act, 1912, 2 of 1912, or any other law for the time being in force relating to cooperative societies in any state. I. Corporation means any body corporate established by or under any central act or state act, but does not include a company or a cooperative society. J. Direct tax means I. Any tax chargeable under the A. Income Tax Act, 1961, 43 of 1961. B. Companies, Profits, Surtax Act, 1964, 7 of 1964. C. Agricultural Income Tax Law. And E. Any other tax which, having regard to its nature or incidence, may be declared by the central government, by notification, to be a direct tax for the purposes of this code. K. Employ means any person other than an apprentice engaged under the Apprentices Act, 1961, 52 of 1961, employed on wages by an establishment to do any skilled, semi-skilled or unskilled, manual, operational, supervisory, managerial, administrative, technical or clerical work for hire or reward, whether the terms of employment be express or implied, and also includes a person declared to be an employee by the appropriate government, but does not include any member of the armed forces of the Union. L. Employer means a person who employs, whether directly or through any person, or on his behalf or on behalf of any person, one or more employees in his establishment and where the establishment is carried on by any department of the central government or the state government, the authority specified by the head of such department, in this behalf or where no authority is so specified the head of the department and in relation to an establishment carried on by a local authority, the chief executive of that authority, and includes, I. In relation to an establishment which is a factory, the occupier of the factory is defined in Clause N of Section 2 of the Factories Act, 1948, 63 of 1948, and where a person has been named as a manager of the factory under Clause F of subsection 1 of Section 7 of the said Act, the person so named. E. In relation to any other establishment, the person who, or the authority which, has ultimate control over the affairs of the establishment and where the said affairs is entrusted to a manager or managing director, such manager or managing director. E. Contractor. And IV. Legal representative of a deceased employer. M. Establishment means any place where any industry, trade, business, manufacture or occupation is carried on and includes government establishment. N. Factory means a factory is defined in Clause M of Section 2 of the Factories Act, 1948, 63 of 1948. O. Government establishment means any office or department of the government or a local authority. P. Income Tax Act means the Income Tax Act, 1961, 43 of 1961. 5. Q. Industrial dispute means I. Any dispute or difference between employers and employers, or between employers and workers, or between workers and workers which is connected with the employment or non-employment or the terms of employment or with the conditions of labor of any person. And E. Any dispute or difference between an individual worker and an employer connected with, or arising out of, discharge, dismissal, retrenchment or termination of such worker. R. Inspector cum facilitator means a person appointed by the appropriate government under subsection 1 of Section 51. S. Minimum wage means the wage fixed under Section 6. T. Notification means a notification published in the Gazette of India or in the official gazette of a state, as the case may be, and the expression, notify, with its grammatical variations and cognate expressions shall be construed accordingly. U. Prescribed means prescribed by rules made by the appropriate government. V. Same work or work of a similar nature means work in respect of which the skill, effort, experience and responsibility required are the same, when performed under similar working conditions by employees, and the difference, if any, between the skill, effort, experience and responsibility required for employees of any gender, are not of practical importance in relation to the terms and conditions of employment. W. State includes a union territory. X. Tribunal shall have the same meaning as assigned to it in Clause R of Section 2 of the Industrial Disputes Act, 1947, 14 of 1947. Y. Wages means all remuneration, whether by way of salaries, allowances, or otherwise, expressed in terms of money or capable of being so expressed, which would, 42 of 2005, if the terms of employment, express or implied, were fulfilled, be payable to a person employed in respect of his employment or of work done in such employment, and includes I. Basic pay, E. Diurnus allowance, and E. Retaining allowance, if any, but does not include A. Any bonus payable under any law for the time being in force, which does not form part of the remuneration payable under the terms of employment. B. The value of any house accommodation, or of the supply of light, water, medical attendance, or other amenity, or of any service excluded from the computation of wages by a general or special order of the appropriate government. C. Any contribution paid by the employer to any pension or provident fund, and the interest which may have accrued thereon. D. Any conveyance allowance or the value of any traveling concession. A. Any sum paid to the employed person to defray special expenses entailed on him by the nature of his employment. F. House rent allowance. G. Remuneration payable under any award or settlement between the parties or order of a court or tribunal. H. Any overtime allowance. I. Any commission payable to the employee. J. Any gratuity payable on the termination of employment. 6. K. Any retrenchment compensation or other retirement benefit payable to the employee, or any ex gratia payment made to him on the termination of employment, provided that, for calculating the wages under this clause, if payments made by the employer to the employee under clauses A to I exceeds 1/2, or such other percent as may be notified by the central government, of the all remuneration calculated under this clause, the amount which exceeds such 1/2, or the percent so notified, shall be deemed as remuneration and shall be accordingly added in wages under this clause, provided further that for the purpose of equal wages to all genders and for the purpose of payment of wages, the emoluments specified in clauses D, F, G, and H shall be taken for computation of wage. Explanation. Where an employee is given in lieu of the whole or part of the wages payable to him, any remuneration in kind by his employer, the value of such remuneration in kind which does not exceed 15% of the total wages payable to him, shall be deemed to form part of the wages of such employee. Z. Worker means any person, except an apprentice as defined under Clause R of Section 2 of the Apprentices Act, 1961, 52 of 1961, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward, whether the terms of employment be express or implied, and includes I. Working journalists as defined in Clause F of Section 2 of the Working Journalists and Other Newspaper Employees, Conditions of Service, and Miscellaneous Provisions Act, 1955, 45 of 1955. And E. Sales Promotion Employees as defined in Clause D of Section 2 of the Sales Promotion Employees, Conditions of Service Act, 1976, 11 of 1976, and for the purposes of any proceeding under this code in relation to an industrial dispute, includes any such person who has been dismissed, discharged, or retrenched, or otherwise terminated in connection with, or as a consequence of, that dispute, or whose dismissal, discharge, or retrenchment has led to that dispute, but does not include any such person, who is subject to the Air Force Act, 1950, 45 of 1950, or the Army Act, 1950, 46 of 1950, or the Navy Act, 1957, 62 of 1957. Or B. Who is employed in the police service or as an officer or other employee of a prison. Or C. Who is employed mainly in a managerial or administrative capacity. Or D. Who is employed in a supervisory capacity drawing wage of exceeding 15,000 rupees per month or an amount is may be notified by the central government from time to time. 3. Prohibition of discrimination on ground of gender. 1. There shall be no discrimination in an establishment or any unit thereof among employees on the ground of gender in matters relating to wages by the same employer, in respect of the same work or work of a similar nature done by any employee. 2. No employer shall, I, for the purposes of complying with the provisions of subsection 1, reduce the rate of wages of any employee. And E. Make any discrimination on the ground of sex while recruiting any employee for the same work or work of similar nature and in the conditions of employment, except where the employment of women in such work is prohibited or restricted by or under any law for the time being in force. 4. Decision as to disputes with regard to same or similar nature of work. Where there is any dispute as to whether a work is of same or similar nature for the purposes of Section 3, the dispute shall be decided by such authority as may be notified by the appropriate government. 7. Chapter 2. Minimum wages. 5. Payment of minimum rate of wages. No employer shall pay to any employee wages less than the minimum rate of wages notified by the appropriate government. 6. Fixation of minimum wages. 1. Subject to the provisions of Section 9, the appropriate government shall fix the minimum rate of wages payable to employees in accordance with the provisions of Section 8. 2. For the purposes of subsection 1, the appropriate government shall fix a minimum rate of wages, A. For time work. Or B. For piece work. 3. Where employees are employed on piece work, for the purpose of subsection 1, the appropriate government shall fix a minimum rate of wages for securing such employees a minimum rate of wages on a time work basis. 4. The minimum rate of wages on time work basis may be fixed in accordance with any one or more of the following wage periods, namely, I. By the hour. Or E. By the day. Or E. By the month. 5. Where the rates of wages are fixed by the hour or by the day or by the month, the manner of calculating the wages shall be such as may be prescribed. 6. For the purpose of fixation of minimum rate of wages under this section, the appropriate government shall primarily take into account the skill of workers required for working under the categories of unskilled, skilled, semi-skilled and highly skilled or geographical area or both. And B. May, in addition to such minimum rate of wages for certain category of workers, take into account the arduousness of work like temperature or humidity normally difficult to bear, hazardous occupations or processes or underground work as may be prescribed by that government. And C. The norms of such fixation of minimum rate of wages shall be such as may be prescribed. 7. The number of minimum rates of wages referred to in subsection 6 may, as far as possible, be kept at minimum by the appropriate government. 7. Components of minimum wages. 1. Any minimum rate of wages fixed or revised by the appropriate government under Section the 8th of may consist of a basic rate of wages and an allowance at a rate to be adjusted, at such intervals and in such manner as the appropriate government may direct, to accord as nearly as practicable with the variation in the cost of living index number applicable to such workers, hereinafter referred to as cost of living allowance. Or B. A basic rate of wages with or without the cost of living allowance, and the cash value of the concessions in respect of supplies of essential commodities at concession rates, where so authorized. Or C. An all-inclusive rate allowing for the basic rate, the cost of living allowance and the cash value of the concessions, if any. 2. The cost of living allowance and the cash value of the concessions in respect of supplies of essential commodities at concession rate shall be computed by such authority, as the appropriate 8. Government may by notification, appoint, at such intervals and in accordance with such directions as may be specified or given by the appropriate government from time to time. 8. Procedure for fixing and revising minimum wages. 1. In fixing minimum rates of wages for the first time or in revising minimum rates of wages under this code, the appropriate government shall either a. Appoint as many committees as it considers necessary to hold inquiries and recommend in respect of such fixation or revision, as the case may be. Or b. By notification publish its proposals for the information of persons likely to be affected thereby and specify a date not less than 2 months from the date of the notification on which the proposals shall be taken into consideration. 2. Every committee appointed by the appropriate government under clause a of subsection 1 shall consist of persons a representing employers, b. representing employees which shall be equal in number of the members specified in clause a, and c. independent persons, not exceeding 1/3 of the total members of the committee. 3. After considering the recommendation of the committee appointed under clause a of subsection 1, or, as the case may be, all representations received by it before the date specified in the notification under clause b of that subsection, the appropriate government shall by notification fix, or as the case may be, revise the minimum rates of wages, and unless such notification otherwise provides, it shall come into force on the expiry of 3 months from the date of its issue, provided that where the appropriate government proposes to revise the minimum rates of wages in the manner specified in clause b of subsection 1, it shall also consult concerned advisory board constituted under section 42. 4. The appropriate government shall review or revise minimum rates of wages ordinarily at an interval not exceeding 5 years. 9. Power of central government to fix floor wage. 1. The central government shall fix floor wage taking into account minimum living standards of a worker in such manner as may be prescribed, provided that different floor wage may be fixed for different geographical areas. 2. The minimum rates of wages fixed by the appropriate government under Section 6 shall not be less than the floor wage, and if the minimum rates of wages fixed by the appropriate government earlier is more than the floor wage, then, the appropriate government shall not reduce such minimum rates of wages fixed by it earlier. 3. The central government may, before fixing the floor wage under subsection 1, obtain the advice of the Central Advisory Board constituted under subsection 1 of Section 42 and consult state governments in such manner as may be prescribed. 10. Wages of employee who works for less than normal working day. If an employee whose minimum rate of wages has been fixed under this code by the day works on any day on which he was employed for a period of less than the requisite number of hours constituting a normal working day, he shall, save as otherwise hereinafter provided, be entitled to receive wages in respect of work done on that day, as if he had worked for a full normal working day, provided that he shall not be entitled to receive wages for a full normal working day, in any case where his failure to work is caused by his unwillingness to work and not by the omission of the employer to provide him with work. And in such other cases and circumstances, as may be prescribed. 11. Wages for 2 or more classes of work. Where an employee does 2 or more classes of work to each of which a different minimum rate of wages is applicable, the employer shall pay to such 9. Employee in respect of the time respectively occupied in each such class of work, wages at not less than the minimum rate in force in respect of each such class. 12. Minimum time rate wages for piece work. Where a person is employed on piece work for which minimum time rate and not a minimum piece rate has been fixed under this code, the employer shall pay to such person wages at not less than the minimum time rate. 13. Fixing hours of work for normal working day. 1. Where the minimum rates of wages have been fixed under this code, the appropriate government may fix the number of hours of work which shall constitute a normal working day inclusive of one or more specified intervals. B. Provide for a day of rest in every period of 7 days which shall be allowed to all employees or to any specified class of employees and for the payment of remuneration in respect of such days of rest. C. Provide for payment for work on a day of rest at a rate not less than the overtime rate. 2. The provisions of subsection 1 shall, in relation to the following classes of employees apply. only to such extent and subject to such conditions as may be prescribed, namely, a. Employees engaged in any emergency which could not have been foreseen or prevented. B. Employees engaged in work of the nature of preparatory or complementary work which must necessarily be carried on outside the limits laid down for the general working in the employment concerned. C. Employees whose employment is essentially intermittent. D. Employees engaged in any work which for technical reasons has to be completed before the duty is over. And A. Employees engaged in a work which could not be carried on except at times dependent on the irregular action of natural forces. 3. For the purposes of Clause C of subsection 2, employment of an employee is essentially intermittent when it is declared to be so by the appropriate government on the ground that the daily hours of duty of the employee, or if there be no daily hours of duty as such for the employee, the hours of duty normally include periods of inaction during which the employee may be on duty but is not called upon to display either physical activity or sustained attention. 14. Wages for overtime work. Where an employee whose minimum rate of wages has been fixed under this code by the hour, by the day, or by such a longer wage period as may be prescribed, works on any day in excess of the number of hours constituting a normal working day, the employer shall pay him for every hour or for part of an hour so worked in excess, at the overtime rate which shall not be less than twice the normal rate of wages. Chapter 3. Payment of wages. 15. Mode of payment of wages. All wages shall be paid in current coin or currency notes or by check or by crediting the wages in the bank account of the employee or by the electronic mode, provided that the appropriate government may, by notification, specify the industrial or other establishment, the employer of which shall pay to every person employed in such industrial or other establishment, the wages only by check or by crediting the wages in his bank account. 16. Fixation of wage period. The employer shall fix the wage period for employees either as daily or weekly or fortnightly or monthly subject to the condition that no wage period in respect of any employee shall be more than a month, provided that different wage periods may be fixed for different establishments. 17. Time limit for payment of wages. 1. The employer shall pay or cause to be paid wages to the employees engaged on 10. I. Daily basis, at the end of the shift. E. Weekly basis, on the last working day of the week, that is to say, before the weekly holiday. E. Fortnightly basis, before the end of the second day after the end of the fortnight. IV. Monthly basis, before the expiry of the seventh day of the succeeding month. 2. Where an employee has been I. Removed or dismissed from service. Or E. Retrenched or has resigned from service, or became unemployed due to closure of the establishment, the wages payable to him shall be paid within 2 working days of his removal, dismissal, retrenchment, or, as the case may be, his resignation. 3. Notwithstanding anything contained in subsection 1 or subsection 2, the appropriate government may provide any other time limit for payment of wages where it considers reasonable, having regard to the circumstances under which the wages are to be paid. 4. Nothing contained in subsection 1 or subsection 2 shall affect any time limit for payment of wages provided in any other law for the time being in force. 18. Deductions which may be made from wages. 1. Notwithstanding anything contained in any other law for the time being in force, there shall be no deductions from the wages of the employee, except those as are authorized under this code. Explanation. For the purposes